Good evening, Alex.
Good evening, Bailey.
And good evening, America. Our top story this evening is the case of Johnson versus San Francisco Unified School District.
Parents of Black children in the San Francisco School District are seeking desegregation of public schools. The plaintiffs claim that the school board had committed de jure acts of segregation and that the responsibility fell upon the school board to desegregate the school system, and they failed.
Both parties have been required to submit a plan to desegregate the schools. The plaintiffs have submitted their Freedom Plan, and the school board has submitted their Horseshoe Plan.
Parents of elementary school children of Chinese ancestry claim entitlement to intervene as a matter of the right rule under Rule 24A2. They oppose the compulsory reassignment of such students to schools outside the area in which they reside, alleging inter alia that such reassignment will make it impossible for such children to attend community schools offering education in Chinese language, art, culture, and history. They contend on constitutional and equitable grounds that they are not properly bound to the court's decree and that they feel to be a part of the rule.
They additionally sought an order shortening time for service of the moving papers so that their application might be ruled upon in time for them to participate in these hearings. The district court refused to shorten time, and the hearings were held without their participation. After the district court denied their application to intervene.
During the hearing, the board has tried to make an argument about the cost and need for more busing that the desegregation of public schooling will create. Judges, however, stated that the evidence demonstrates that there simply cannot be desegregation without some busing of some students because there are districts in the city in which there are great distinctions of members of one particular race. The evidence also showed that the problems with the board was trying to make with busing were not as much of an inconvenience as they were trying to make them.
It was proven that the constitutional rights of children to equality of educational opportunity are being denied. The law requires the promptest possible correction, overriding considerations of expediency, such as cost and inconvenience. The court approved both plans and directed defendants forthwith to carry out desegregation of the elementary schools in the manner provided by one or the other of the two plans. Though they stated that both plans fulfilled the law, the judges made a point to mention that the Freedom Plan made by the plaintiffs does much more to effectively desegregate the schools and promote inclusion.
On a long list of failures of the board, it was proven that there was a failure to take steps to bring the racial balances in elementary schools within the guidelines set by the State Board of Education, and prolonged failure to pursue a policy of hiring teachers and administrators of minority races.
These failures also included failure to adopt sufficient measures to improve the education of children in predominantly Black schools, despite the board's knowledge that their education in these schools was inferior to that provided in predominantly white schools. There was also failure to accept suggestions offered by school officials regarding the placement of new schools so as to minimize segregation. The list goes on.
And now to us again with the facts.